let's try and start this off then. So thank you very much, everyone, for joining us for this, the second of the Landmark Chambers Property and Quarantine series. I'm Justin Bates. I'm presenting today with Nicholas Grant, colleague in Chambers. Yesterday, of course, we looked at housing standards, and today we're looking at landlord licensing in England. The tone and the structure of today is going to be quite similar to yesterday. So a bit of a mix of building blocks and then some hot topics. And the reason for that is very similar to yesterday. It's quite a diverse bunch of people in on this: landlords, local authorities, some tenant advisors, etc. And so we want to make sure there's something that everybody takes away something useful from. In the same way as yesterday, you've got question facility in the chat function. If you stick things in there, we will try and pick them up during the webinar or at the end. And if you don't get a chance to ask it during the webinar, you can still stick something in the chat box, because the plan is at the end of these 4 seminars, we're going to collate all the different questions and try and send out some sort of useful briefing or summary note to people of the main issues that came up. Why landlord licensing, you may ask? It's not as if there's been any particularly radical changes to the Housing Act 2004 licensing provisions in the last couple of years. The last big change was probably the 2018 SI affecting the criteria or the categories for setting up certain licensing schemes. I think for a couple of reasons. One, there's been a rush would be unfair, but there's certainly been a number of interesting cases from the upper tribunal in the last year or so, I would say, about how licensing ties in with the fixed penalty notice regime. And secondly, it seems to me that licensing is something that's going to become more important if and when the government moves ahead with its abolition of Section 21, the no-fault right to possession. Because presently, as you all know, Section 21 is used as a vehicle for driving up standards in the private rented sector. So if you haven't done a gas safety certificate, for example, you can't use Section 21. If you lose Section 21 and you lose that as a driver for standards, you're going to have to think about how you enforce standard through other means, and licensing is probably the most obvious way of doing it. So with that in mind, the next slide, after the rest there, what we're going to talk about today, we're going to try and get through in half an hour the buildings that need a license. It won't be all of them, it'll be a bit of an overview. How you get a license, and there's some quite interesting stuff in there arising out of a case called Gaskin. The terms of a license, and then briefly, the consequences of failure to get a license. So, without further ado, Nick, would you mind just summarising all of the different categories of building that need a licence?
Sure. Really small and very easy. So we're concerned with predominantly 2 schemes today. The first is HMOs and additional licences, and they're all catered for under Part 2 of the Housing Act. The second is selective licensing under Part 3. So HMOs need to be licensed if 1, they're an HMO, 2, they're an HMO to which the part applies, and 3, they need to be licensed under Section 61. The definition of an HMO can be found in sections 254 to 259. There are 5 tests, which are frankly all quite complicated and won't do today, but basically we're looking for people who live together and share amenities, but who are not part of the same household.
I was going to interpose there for a minute, because this is a chance for me to tell my favourite story about household. You will all be pleased to know that there's quite some detailed law on what constitutes a household. And for all those of you who are worried about the position of your live-in butler or staff, you'll be pleased to know that your butler and your staff all count as your household for these purposes. It does just make me chuckle that in 2004, a Labour government with a stonking great majority turning round to reform the law of housing standards and landlord licensing, made sure that people with butlers didn't suddenly find themselves subject to HMO provisions. It's one of the reasons why Buckingham Palace isn't an HMO, despite passing a number of tests for it. Anyway, sorry, I just digress. It just always amuses me that my butler, should I ever have one, is part of my household for these purposes.
So, having established what an HMO is, the second question that you'll need to ask is whether it's an HMO to which Part 2 applies. There are 2 ways this can occur. The first is whether it falls within a prescribed description. Now, this is mandatory, and the Secretary of State has set out in the Licensing of Houses in Multiple Occupation Prescribed Description Order 2018, and you've got the SI reference on your slide, what constitutes a prescribed description. So at the moment it's HMOs occupied by 5 or more persons, or occupied by persons living in 2 or more households, and meets the standard test, self-contained test or converted building test, which are 3 of the tests to determine whether something's an HMO under section 254. Prior to this 2018 SI, there was a requirement that there had to be multiple stories to the property, but that's now removed. So if your HMO falls within that prescribed description, it needs a license. If it doesn't, then it may still do so if it's in an area designated by the authority under section 56 for additional licensing. Now the LA can designate an area as subject to additional licensing if it considers a significant proportion of properties so managed so ineffectively that it's giving rise to a particular problem for occupiers or members of the public. That designation will lapse after 5 years if it's not revoked before. So those are the first 2 criteria. Is it an HMO, and then is it prescribed or in an additional licensing area? The third is whether it needs a license. And you see that in section 61(1), and effectively every HMO to which the part applies, which is the last 2 things we've looked at, needs a license unless there's a temporary exemption notice in force or an interim or final management order in play. Now, if you've made the application, deeming provisions mean that an application is enough. So if you've made an application, then you can get into the, you're not going to get into difficulties that way. So that's the broad outline of HMOs, and sorry, it is quite quick. The selective licensing provision, or Part 3 houses, follow a similar sort of structure, though there are some differences. So Part 3 regulation applies to 1, houses to which the part applies, rather unsurprisingly, and 2, which are required to be licensed. Now, houses to which the part applies are those that are in an area designated under section 80 as subject to selective licensing, and which are occupied by licensees or tenancies which are not exempt. I'll come back to that in a second. But the designation of areas is controlled by sections 80 and 84. In a not dissimilar way to the additional licensing provisions, designations, if a local authority makes a designation, need confirmation by the national authorities, and again, they last for 5 years unless they're revoked sooner. Now, an authority can designate an area or part of its area under section 80 if one of sort of 3, sort of 7 conditions are met. So there are 2 conditions that are outlined in the statute themselves, and you've got those on your slides under under little 1 and little 2. And the third provision in the statute says all such other conditions as are made by a SI, and the Secretary of State has made an SI, and that's where you get the housing conditions, migration, etc. It's subsection 3 from. It's good to know that that exists and bear it in mind, because if you're looking through the statute, there's not actually an indicator that that's been made. So do bear in mind that that is there. So the general conditions 1 and 2, the ones that are found in the statute, the first is that an area is or is likely to become an area of low housing demand, and making the designation will contribute to the improvement or social or economic conditions of the area. The second set of general conditions is that there's a significant and persistent problem with antisocial behaviour. Some or all of the private sector landlords are failing to take appropriate action, and again, making the designation will help. The third condition, or that has 4 rolled up within it, those under the license, those under the SI, can be used if the area, there are 3 requirements. The first is that an area contains a high proportion of properties in the private rented sector in relation to the total number of properties. The second is that those are occupied under ASTs or licenses. And the third condition is that, again, one of those 4 conditions relating to housing conditions, migration, etc., are satisfied. So I'll take these very, very quickly. The housing conditions point is that after carrying out a review of conditions, the LA intends to carry out inspections of the properties, and making the designation will help. The migration condition is that the area has experienced a significant influx of migration. A significant number of properties are occupied by those migrants, and making the designation will contribute to preserving social or economic conditions. The deprivation condition is that the area suffers a high level of deprivation. You can look at things like employment, crime, etc. And again, making the designation will contribute to a reduction in that. And the fourth is that the area suffers high levels of crime that affects those in the properties or other households or businesses. And again, making a designation will contribute to a reduction in crime.
I said I was going to throw in hot topics and questions. So here's one for you. Property guardians, are they within Part 2 and Part 3?
Well, MHCLG has been pretty coy about this, but I think we're moving towards a situation where the answer is yes. And in fact, that should be addressed here. It's almost like I knew it was coming. So I'm going to take the cases under property guardians in reverse order. So we started with Colchester Council and Camelot Guardians, which is where Colchester Council prosecuted Camelot, which is a property guardians firm, for failing to license under the HMO regs. Camelot simply pleaded guilty, so there's no judgment on it, and then avoided a hefty fine effectively by folding. We then get the FTT decision in Oxley. Now, this is a rent repayment order case, which rent repayment orders will be covered at the end, and then more in seminar Justin does with Brooke later. But it was contended in part by live-in guardians that the property didn't require an HMO, again, because it was just property guardians. The FTT at paragraph 50 of the judgment said the building was an HMO. Finally, we get to Ludgate House and Ricketts. This is an upper tribunal decision. And I think it's Martin Roger. It might be Mr. Justice Holgate. Either way, it's someone to pay attention to. Now, this is fundamentally a rating dispute, but in outlining the material facts, the upper tribunal noted that it had been put to them by counsel for Ludgate House that no HMO was required. And they say at paragraph 48, we are satisfied that Ludgate House became an HMO once the licensees moved in and satisfied the standard test in section 254. So yes, I think the strong steer is that property guardians are, in fact, do need HMOs or various licenses.
Yeah, despite what many property guardian companies think, I think that's probably right.
Sure.
And for the local authorities in here who are listening to this, property guardians are definitely ones you want to think about going after, because you'll be fully aware the problem is that you put property guardians into property that isn't really designed for living in, office space, old, abandoned hospitals and such like, and the conditions are normally pretty terrible. I think there is a case in there just waiting to go to the Court of Appeal and find out what the answer is. But yeah, I agree with you. The trend seems to be towards thinking that they are covered. So, all right, how do you get a license?
The short answer is apply. Intuitive.
That was easy. Next.
Yeah. So you apply to the local authorities in accordance with the requirements and fees the local authorities fix, and any other requirements laid out by the Secretary of State. The Secretary of State, there's a 2006 SI, again, you've got the reference on your screens, which lists various declarations that have to be made and various information that can be required, things like name, phone number, and a lot of details about the house, like number of stories, rooms, bathrooms, etc. The reason Gaskin's at the bottom is because it starts to get into quite an interesting discussion of what the fees can cover. And so Mr. Gaskin gave rise to both of these cases. The facts, in short, were that he ran a number of HMOs that had for which he had licenses. He applied for renewal of those in about 2014. The local authority required a payment of £1,799, which, as it came out, was A, the same fee as would have been required for a new licensee, and B, included a proportion of costs for running and enforcing the licensing regime, whether or not Mr. Gaskin actually got his license. He refused to pay and only paid £850 instead. The local authority said that's not enough, and then, of course, took him to court. They paused the MAGS proceedings against Mr. Gaskin so that he could JR the policies. And there are really two arguments he put forward. The first, which was dealt with in the 2017 case, is that it was unlawful for the authority to charge the same fee for renewing a license as it would be for a first application from a licensee. The court said no and dismissed that. The second and a lot more interesting argument came in the 2018 case, and this was a divisional court case, that here basically argued that in providing accommodation for a profit, he was providing a service within the meaning of the EU Services Directive 2006-123-EC for anyone making notes. The Services Directive prohibits authorization schemes from effectively being difficult. And there had been a Supreme Court case in 2015 and then a Supreme ECJ judgment in 2018 that says the Services Directive prohibits payment of a fee at the time of submitting an application if that fee or that part of that fee relates to a sum for managing and enforcing the authorization scheme. Now that's the case even if the fee, if you're unsuccessful, is then refunded to you, or that proportion of the fee is refunded to you. In Gaskin, the divisional court said that yes, Mr. Gaskin was in fact providing a service within the directive. And in accordance with the ECJ's judgment, the local authority could not therefore require him to pay a sum on the application that related to his fees, to the costs of running the scheme, not just processing his application.
Yeah, I mean, I think the Gaskin case is the second one in particular is really important, and I know a lot of local authorities struggle with it. It's this divide between the fee you can charge to cover the cost of processing the application, which everyone has to pay, and the fee you can charge to represent your expected costs of enforcing and operating the scheme over the life of the license, which you can only charge to the people who get the licenses. So it's this two-stage process for the fee, and it means you've got to know as an authority what element of the fee provides what element of the service. The authority, I've looked at this a lot, authorities in London and bigger metropolitan areas seem to have got their head around Gaskin, but outside of London and the big metropolitan areas, Gaskin does not seem to have filtered down to general awareness. And so it seems to me there's quite a few authorities who risk getting their fingers burnt if they don't pick up on Gaskin and make the necessary changes.
There's a further particularly interesting potential implication of Gaskin, which I'll come to now. Now, obviously as an authority, when you receive an application, you have to either grant it or refuse it. But now that this is a service under the meaning of the Service Directive, there are a number of obligations imposed by that directive on local authorities, some of which we saw in Gaskin relating to fees. But another one I picked out is Regulation 19. So the services regs are how the directive is brought into UK law. Now that says at number 1, of course, that applications have to be processed within a reasonable time. Subsection 5, it says failure to process within a reasonable time will lead to deemed consent. So it's quite possible, certainly an argument, that if you don't process these applications within a reasonable time, a potential licensee could make an argument relying on deemed consent rather than actual consent.
Yeah, I have to say, I think that's the really, really interesting next stage for Gaskin. I think you're right. If you fail to deal with your application in a reasonable period of time, you're deemed to have got it. And what would be I think would be really interesting is someone who applies. If their application had been processed promptly, they probably wouldn't have got the license. Let's say they've got some serious criminal convictions. But because the authority can't process it within time, they're deemed to grant it. How does that pan out? I think there's a lot of litigation to have in there, I have to say.
I tend to agree.
Yeah. So
right. In terms of what the authority must look at when deciding to grant the application, various tests are outlined in section 65 and 66 for HMOs and 88 for Part 3 licenses. Now, the section says that they may, and it's important, grant the license if it satisfied that, and then it lays down those 5 tests. The 6 is for HMOs only, but that the potential license holders are fit and proper person, and the most appropriate of the potential license holders, that there's no banning order, that the manager has control of the house or is an agent of the person that does, that the manager is a fit and proper person, that the proposed management arrangements are otherwise satisfactory, and for HMOs, that the house is reasonably suitable for occupation by the number of households in the application or another maximum number of households that the local housing authority decides. The reason that may is important is because it seems there's still a residual discretion to refuse permission even if these factors are satisfied, and that's what came out in Khan. Now, it's not clear how far that extends. In Khan, the permission was, they took, planning considerations into account, and it was to do with antisocial behaviour and presenting antisocial behaviour. Query whether you'd be able to take the same thing into account if you were trying to, if the local authority was trying to rectify issues of low housing demand, quite possibly. So there is a discretion there, but it's not clear how far beyond immediate concerns of licensor and licensee that applies.
Do you think there is a discretion? I mean, the paragraph, I know Khan says there is, but it's only the upper tribunal, so let's not get carried away. I mean,
you say it's only the upper tribunal?
Yeah, but I mean, there's no analysis in that paragraph. There's one paragraph in that judgment in which he says may obviously confers a residual discretion, but he doesn't analyse it, and he doesn't look at all the case law where may has been held to mean must, etc., or must has been held to not mean must, etc., etc. You know, language. We all know that you can make a statute say whatever you want to. I find Khan quite a difficult case because it's only the upper tribunal, so it's binding on the FTT, but there's no real analysis of this discretion point. And in any event, if there is a discretion, he does tie it in the judgment very closely to the purpose of the underlying licensing scheme. You know, I can see why a breach of planning permission is relevant. If you're worried about antisocial behaviour, then the fact that someone's unlawfully turned this property from a one-bedroom house into a seven-bedroom HMO is obviously relevant to antisocial behaviour because it means the building's going to be overcrowded, it means that there'll be a density of use that isn't appropriate, etc., etc. And that it is likely to lead to problems with management. But if you were doing it on the basis of low housing demand, why should the breach of planning permission matter? Anyway, that's my view on it. I wouldn't regard Khan as the last word on this. I can imagine that if someone has their license refused for a reason that isn't in one of those categories, I'd be tempted to push that. But you may not agree.
I would need to sit down and think a lot more about it, I think.
Well, what's our next one? Our next one's about a case that you and I lost together, isn't it?
It is, yes.
So we should probably deal with that one then.
Sure. Okay. So the fit and proper person test outlined at section 66 and 68. We see this a lot. This isn't just in house and multiple occupations, HMOs or even selective licensing, but it comes up in, for example, things like taxi licenses. Now, the section says that the authority may have regard to the fact that the P, who's the person that they're looking at, or any person currently or previously associated with P, whether through personal work or otherwise. So it's extremely broad. They look at evidence as to whether P or that person has committed offences concerning fraud, dishonesty, violence, drugs, sexual offences, unlawful discrimination in connection with carrying on a business, or contravened landlord and tenant law or housing law, or has acted not in accordance with a code of practice under section 233. Or, and there is a scooping up provision, evidence that the local housing authority thinks is relevant. So it's an incredibly broad provision. And the case Justin's talking about that's on the bottom of your screens is one where the question arose whether it can take into account spent convictions, because we've got the Rehabilitation of Offenders Act 1974, which provides that if you've got a conviction once it's been spent, it can't be taken into account in law. Now, the practice of local authorities on spent convictions varies. Some take it into account, some don't. Hussein, which is in the upper tribunal, has effectively come down and says you can take into account the behaviour but not the conviction itself. Now, there was an earlier High Court judgment saying you leave both out of account. Hussein has said that is wrong. So it looks like we'll be going to the Court of Appeal later this year on that. But yes, so far the discretion to take into account evidence seems extremely broad.
Yeah.
Justin, is there anything we want to say on Hussein before I move on to terms?
No, just that we'd better win it in the Court of Appeal.
Sure. Okay.
Let's try and deal with terms fairly briefly, because we've got a couple of minutes left. I don't want to overrun by too much. But we're making good time.
Okay. In that case, I'll rattle through this slide fairly quickly. These are effectively sort of mandatory provisions, ones that always have to go in. Bear in mind, I think the only point I'm going to bring out here is that these licenses are not transferable. MENA concerned someone who bought an HMO, thought the license was transferable, belatedly realised it wasn't applied, and then had a rent repayment order made against them for not having a license for that particular period. So the imposition of conditions is dealt with at page 67, section 67 and 90 to 91, schedule 4. So again, the sections for HMOs and for Part 3 licenses are in very similar terms, but they're not in identical terms, and those differences between them do become quite important in the case law. So, for example, the first one, it may include conditions appropriate for regulating management, use and occupation of the house, but its conditions and contents is only for HMOs. There's not a conditions and contents leeway in Part 3 licenses. Must include various conditions in Schedule 4, things like the licence holder must produce a gas safety certificate, may not impose conditions on a person other than the licence holder, or seek to alter the terms of the tenancy. Now, because these conditions can be imposed by both local authorities, and then the FTT can have play around if there's an appeal, we've had a couple of, or in fact, 3 fairly important cases on this, which are at the bottom of your screen. So Nottingham and Parr effectively said that you could use, or the local housing authority could use these terms to regulate who lives in a property. So a term that, for example, a room was going to be occupied only by students was totally fine. There's some wider points in this as well about the extent to which you can take, or a local authority can take, communal rooms into account in deciding whether that evens out bedrooms that are slightly smaller than mandatory minimum and prescribed standards. So it certainly bears rereading. Brown and Hindburn concerned a property in a selective licensing scheme. The authority granted the application for a license, but included conditions requiring the landlord to install a carbon monoxide detector on the property and ensure it was covered by a valid electrical installation condition report. Now, as I've said, Section 67 for HMOs allows the imposition of conditions for conditions and contents. Section 90, which is the equivalent for Part 3 houses, does not, and this was a Part 3 house. So the Court of Appeal said you could not regulate the contents under Section 90. They didn't have that freedom. The last, the other tribunal case of Berg and Burnley, effectively it said that the housing authority imposed conditions under a Part 3 licence to attend a training course on how to manage tenancies. In Section 67, which is the HMO equivalent, it explicitly allows the imposition of conditions to attend training courses in relation to codes of practice. There is no equivalent in Part 3, so the landlords tried to rely on the Court of Appeal case in Brown and Hindburn. So Brown was then reviewed by Judge Cook in the upper tribunal, and she effectively said that both 67 and 90 allow the imposition of conditions relating to the management of property, so she brought it in that way, and therefore found that the training condition was acceptable, notwithstanding that difference. So that's terms of a license. Again, Justin, was there anything you wanted to say?
No, I don't think so on those. Let's just touch up on failure to license, then there are some questions come in that we'll try and deal with.
Okay, we'll do failure to license fairly quickly because a lot of the enforcement issues are going to be covered by you and Brooke later. So you cannot serve a Section 21 notice. You could be liable to a rent repayment order, which are one of my favourite things to act on because they're a lot of fun, less so for the landlord. It's a criminal offence to have an HMO or Part 3 house and not have got a licence for it, and you can receive a fixed penalty notice. Now this is, if the local authority issues a fixed penalty notice, that's instead of prosecution and a conviction. In our experience, they tend to rather like issuing these because they get to keep the money. The amount is determined by the local authority, and there's a maximum of £30,000. Again, you can appeal to the FDT and it's reviewable. And Waltham Forest and Marshall, again, the references on your screen, is a case in which Judge Cook goes through effectively how the tribunals on appeal/rehearing should be treating the local authorities' determination of the quantum when that quantum is in line with their policies. And it's basically, in a nutshell, it's not kind of judicial review hands off. Is a rehearing, but according great weight to the elected functions of the local authority. So they can depart if they think it's wrong, but be wary of the fact that the DLA is the democratically elected body. The reason I put Pearson and Bradford down there is because Schedule 13A deals with the procedure for this. That doesn't have a limitation period in it, but Bradford says the standard FTT limitation period of 28 days applies.
Just one quick thing on those fixed penalty notices, because we will talk about them more in Seminar 4. The reason why they're so fantastic if you're a local authority is that these penalties can rack up fairly quickly. So there was a case in the Upper Tribunal about 2 months ago involving Norwich, where they'd managed to, Norwich had served enough fixed penalty notices that the company was on the hook for, I think, £235,000 in penalties. And the director, because you can make directors liable as well, was also on the hook for about 230 grand's worth of penalties. Now, the Upper Tribunal thought that was a bit over the top, but not by very much. I mean, they reduced it to, I think, off the top of my head, 100 grand for the director and 170 grand for the company. All of these things are payable within 28 days, and they're recoverable as debts if they're not. You know, the Upper Tribunal seems quite keen to support local authorities on these penalty notice claims, and the money can rack up fairly quickly. So if you're a local authority, because you get to keep the money, you can almost get the hallowed state of having a polluter pays principle, whereby the worst landlords get hit with the fines, and the fines are then kept to help you pay for your private rented sector enforcement team, who go around then picking on the worst landlords. So if you're a local authority and you want to have a sort of virtuous cycle, that's how you do it now, fixed penalty notices. I don't think authorities should ever really prosecute. They should be looking to use these fixed penalty notices because they're much more effective. That's a bit of a rattle through. We've had some questions come in. I'll pick up on those now while Nick has a glass of water and recovers from his whistle-stop tour. A couple of questions about the tacit consent and the deemed renewal under the services regulations. What's a reasonable time? How long's a piece of string is the problem. At the moment, a reasonable time is probably longer than it was this time last year, because at the moment there's a public health crisis. That means that people can't process their applications as easily. A year strikes me as probably a bit on the long side. 7 weeks is probably okay. It's a question of fact and degree. Seems to me, if the authority could show that they were actively doing something with the application, e.g. they were asking more information or such, then that might be a reason to give them more time. But if they just sit on it and do nothing, tacit consent starts to come into play at that stage. On what date would you apply for renewal if you got a tacit consent? I don't know is the answer, because I'm not aware of anyone who's ever got tacit consent. I am running a tacit consent case for someone at the moment. I assume, but this is only an assumption, I assume you would say that what was granted is the normal 5-year license that most authorities grant as of right. So you'd presumably want to say tacit consent is to a license that would normally be granted. It's not tacit consent to some bespoke individual form of license that only lasts for a period of time. That, I think, would be my approach to it. Can you serve a Section 21 notice in an HMO where a license has been applied for but not yet granted? Yes. What matters for these purposes is that you have applied for the license and it has not been refused. So for the purposes of Section 21, there's a deeming provision that as long as you've applied, that's enough. And there's a very particular question about Bexley Council, which I don't know. I'm not going to answer because Bexley Council might also be on the call. And that's probably a bit of an interaction with planning law. I'd probably want to talk about, it's the danger with doing these things on the hoof about individual councils. I'd want to have a bit of a look at the policy itself, have a look at the planning permission policies. But an HMO, if you're an owner-occupier, you can't be an HMO. So I think I'd need to see some of those documents in a bit more detail. If a Section 21 notice can't be served, can you serve a notice to quit? Not on a short hold tenancy. NTQs don't have any effect on tenancies governed by the 88 Act. So if you've got a tenancy governed by the 88 Act, you can only get someone out by using Section 21 or Section 8. You can't serve a notice to quit. You can't forfeit. If you can't use one of those two statutory notices, you can't get them out. What's the position where the licence is refused between the service notice being served and proceedings being issued? I don't know. I would have to go and look it up. And I will look it up and I will email you the answer to that one because I don't know off the top of my head, I'm afraid. Any more questions coming in? Just trying to have a look at those. Nick, have I missed any? You've got them there.
Just got one about an RRO.
Does the rent repayment order make rent not due? Or no, no, the rent's still due. The whole point of the rent repayment order is they have to repay rent that's been paid. So the way it would work for an RRO is I am a landlord of an unlicensed property. I have a tenant in who pays me £10,000 in rent for a year. During that year, I am unlicensed. So you apply for an RRO and you'd apply for one for £10,000 because you'd say, I've paid rent to an unlicensed landlord, therefore I'm entitled to have it back. Guarantors shouldn't really be affected by this position. Right. Any more for any more? No? Well, having managed to stick to time last time, we're 10 minutes over this time. I hope this doesn't bode ill for next Tuesday. We end up being 20 minutes over. Thank you very much, everyone, for listening along. I appreciate we ran through a lot in there. If you have nothing better to do on Tuesday next week, then please join us for the third of this series when we're going to look at the regulation of letting agents, which is something I suspect that very few people have turned their mind to, including, I fear, many letting agents. Thank you very much, everyone.